Law and Policy Symposium. For those of you who don't know, my name is Lauren Sampson and I'm the EIC of the Journal. And we're very excited to present our first speaker, Lynn Beller, who is the Assistant Dean and Chief of Staff at Columbia Law School. As you probably saw in our posters, the topic for this year is domestic violence. So we're going to be featuring a number of different speakers on that topic. So today is Ms. Beller. Tomorrow will actually be a student panel, one of the first time that's been done for our journal's history, and I think for the school, on which myself, Tally Wood, Yolene, Christine Kim, and Sarah Chappell will be presenting their notes on a variety of DV and other sexual violence issues. And then on Thursday, we're going to have Professor Tom Lininger from the University of Oregon doing his talk also related to DV. So we thank you all for coming, and we encourage you guys to ask a lot of questions afterwards for Ms. Beller, and to please let us know if you have any interest in receiving copies of the talk or anything like that. But the articles at which these are based will be coming out in our spring symposium issue in March or April. So thank you very much.
Thank you. Thank you all for coming. My talk is focused on a paradigm-changing case in the area of child welfare and domestic violence called Nicholson v. Williams. This case challenged the practice of New York City's government child welfare bureau, called the Administration for Children's Services, or ACS, of removing children from their mothers solely because the children saw their mothers being beaten by their intimate partners. I want to frame the procedural aspect of the case and tell you why it was a landmark case against one of the largest child welfare agencies in the country. Although this was a New York City and New York State case, it had reverberations around the country and even around the world. In this case, mothers and children brought a civil rights action in federal court challenging the constitutionality of the city's policy of removing children from the mother's custody solely because the mothers had failed to prevent the children from seeing domestic violence. Judge Weinstein in the U.S. District Court for the Eastern District of New York certified a class action and granted a preliminary injunction against the city and ACS. New York City appealed. Judge Katzman of the Second Circuit, before reaching the federal question, certified 3 questions regarding the scope of the state statutes. Judge Kaye, Chief Judge of New York's highest court, the Court of Appeals, articulated a new standard for removals that is now controlling law in New York State. This case raised questions of federal and state law, and New York's smartest legal minds engaged with these difficult questions. I would like to tell you a little bit about how I became interested in the topic. When I was a law student at Columbia, I was introduced to an organization called Sanctuary for Families. Sanctuary is New York State's leading provider of services and an advocate for survivors of domestic violence, sex trafficking, and other forms of gender violence. Sanctuary empowers thousands of adults and children to move to safety and stability through a holistic approach that includes offering services of clinical, legal, shelter, children's counseling, care, and economic empowerment. And of course,
if you want to speak at the podium, then that way the sound will be recorded and stuff. And then you
oh,
can
sorry.
use the
Okay.
microphone.
Okay.
Sorry.
And just for those of you who are going to work in New York, either in the summers or eventually, you can get involved with Sanctuary for Families. It's a fantastic organization. And you might have seen a couple of weeks ago, 2 of Sanctuary's clients, along with the director of the Anti-Trafficking Initiative, were featured in Newsweek in a cover story about the intersection between sex trafficking and migrant farm work in the U.S. I served on the board of Sanctuary for 9 years, and Sanctuary attorneys were involved from the very beginning in bringing the Nicholson case to trial. But I had a feeling that current practices might not be consistent with the decision. So I decided to test my hypothesis and investigate. I contacted Brooklyn Defender Services, which is an organization that provides high-quality legal representation to individuals who cannot afford to retain an attorney. And indeed, they had current cases where children were being removed inappropriately and mothers were being prosecuted for neglect in violation of the Nicholson holding. This talk is about some of those cases. They take place in New York, but they could take place anywhere in the U.S. I also want to note that I focus here on women because in the vast majority of cases, women are the victims. Since this is pretty much a self-selected and knowledgeable group, I'm just going to refresh on the basics of domestic violence. It's a pattern of gender-based intimate partner abuse designed to harm the physical and psychological well-being of the victims. Abusers use not only physical abuse, but also more subtle forces, including intimidation, coercion, emotional abuse, isolation, and economic pressure. I'm sure many of you are familiar with the power and control wheel, which originated in Minnesota in the 1970s and continues to be tremendously influential in the field. It helped experts and the general public realize that domestic violence includes the use of power in many ways and is not limited to physical abuse. These forms include psychological abuse, economic abuse, reporting the victim to law enforcement or child welfare agencies, and threatening deportation. Despite increased awareness of the effects of domestic violence by the legal system and society, and despite efforts of advocacy organizations, domestic violence remains a public health crisis in the world. In 2013, WHO estimated that 1 in 3 women has experienced intimate partner violence. Of course, in many cultures, there are also issues about reporting, so it's likely that there is significant underreporting here. But it's amazing to note how prevalent it is worldwide and consistent across cultures. In the U.S., the CDC has estimated that 1 in 3 women has experienced rape, physical violence, or stalking. In a report issued in 2014, the CDC estimated that 15% of women nationally have experienced intimate partner violence. And it's important to remember that there are also secondary effects of this violence in terms of the economic cost of missed work days, medical attention, shelter, and other services. As Cyrus Vance, the Manhattan District Attorney, noted recently, domestic violence has remained a stubborn problem in the city, even as murder, assault, and other violent crimes have fallen significantly in the last decade. His office prosecuted 6,500 cases in 2013, up from 5,600 a decade ago. And last year, the police department, the New York City Police Department, responded to 284,660 reports of domestic violence citywide, or almost 800 a day. Each year, up to 10 million children are exposed to domestic violence. Child abuse occurs in 50% of domestic violence cases, and a batterer is about 4 to 6 times more likely to sexually abuse his children. Obviously, we want to keep children away from witnessing domestic violence if possible. So this leads us to the most common question. If domestic violence has all of these negative effects on the victim and her children, why doesn't she just leave? There are many questions, there are many reasons for this, some of which are fear of retaliation, economic dependence, desire to keep the family together, and in the case of immigrants, their undocumented status. One of the most important obstacles is that victims know that the most dangerous time for them to leave is when they are contemplating leaving. A victim is at the greatest risk of severe violence and death at the time she's attempting to end the relationship. And this is very important because it becomes the underpinning for Judge Kaye's opinion. Now, let's look at the legal framework in New York. New York State's Family Court Act defines a neglected child as a child under the age of 18 whose physical, mental, or emotional condition has been impaired or is in imminent danger of becoming impaired as the result of the failure of his parent or guardian to exercise a minimum degree of care. During the 1990s, ACS began the practice of removing children from battered mothers alleging that they had engaged in domestic violence. In 2002, at the time of the Nicholson case, New York City claimed that exposure to domestic violence constituted per se emotional harm to a child under the statute. The city claimed that this harm was so great that ACS could do away with the requirement of a court order and simply remove the children wherever domestic violence was found. At this time in New York, there were also other things going on. There were headline-grabbing incidents of child abuse and class actions filed for violations of children's rights. This led to increased pressure on child welfare workers to make the correct decision. But there was an inability to balance the harm from witnessing domestic violence against the harm of removing the children. This led to an approach of when in doubt, take them out. In other words, any doubts as to the safety of the child, they would immediately remove them. And they were unable to provide a balanced assessment because they recognized that if they recommended returning a child to a deadly home, it would be a career ender and would sully their reputations forever. This fear of making a mistake, coupled with the kind of victim blaming that's so typical in domestic violence cases, led to a policy of removing the children from their mothers. So often in the field of domestic violence, progress depends on one good judge making good decisions. And here we have a very good judge. Judge Weinstein is considered one of the most independent and innovative federal judges in the country, with a dramatic and influential impact on American law, especially in mass torts. It was truly fortuitous that the case was considered by a judge like him, who refused to accept the status quo and would champion the rights of victims of abuse. Nicholson v. Williams began with 3 plaintiffs, then grew to a class of 10. It attracted amicus briefs from all over the country, and 44 witnesses testified. Several leading national experts testified on the impact on children of witnessing domestic violence and the impact on children of being removed from the non-offending parent. They said that witnessing domestic violence is sometimes, but not always, harmful to children. And even when it does harm, removing the children from the non-offending parent is more harmful. One expert testified that a removal under such circumstances is tantamount to pouring salt on an open wound. Charlene Nicholson was the lead plaintiff in the case. In 1999, she was a single working mother of 2 young children. She had an 8-year-old son from a previous relationship and a 3-year-old daughter from her relationship with a man named Claude Barnett. Claude lived in South Carolina and made monthly visits to Brooklyn to visit the family. On one of his visits, Charlene told him she wanted to end their relationship, and he assaulted her. He had never previously acted violently towards her. The assault occurred during the day, and Charlene's son was at school, and her daughter was in the crib sleeping next to the room. When Claude left, Charlene called 911 and arranged for a neighbor to care for her children and while she went to the hospital. In the emergency room, she discovered that she had suffered a broken arm, fractured ribs, and head injuries. 3 police officers came to see her in the hospital, and when she found out that she would have to stay in the hospital overnight, she gave them the names of 2 family members who could care for her children. But instead of bringing the children to these relatives, the police informed Charlene that her 2 children had been taken from her by ACS and placed in foster care. The reason given by ACS was that Charlene, the victim, was guilty of child neglect from having engaged in domestic violence. The following day, an ACS worker refused to tell her where her children were and told her that if she wanted to see the children again, she had to appear in court the next week. Despite requests from Charlene to allow her children to stay with relatives, they were eventually placed in foster care with strangers. An ACS worker was assigned to the Nicholson case. In his deposition at trial, he conceded that it was common in DV cases for ACS to wait a few days before going to court after removing a child, because as the mother gets increasingly desperate to get her children back, she will agree to any and all of the conditions required by ACS for the children's return. He testified that he did not believe that Charlene was actually neglectful, but hoped that she would be forced to cooperate to protect herself and her children. He did not file a petition with the family court until 3 business days after the children were placed in foster care. In his testimony, he tried to justify his approach by stating that he believed it would not be safe for Charlene and her children to return to the residence and that she had never obtained an order of protection. If he had properly investigated, he would have discovered that Claude Barnett lived in South Carolina, did not have a key to the apartment, and that Charlene had tried to obtain an order of protection but was denied because Claude Barnett lived out of state. Judge Weinstein concluded that the allegations of neglect on the part of Nicholson resulting from the case manager's failure to properly investigate the situation evince either blatant bias against victims of domestic violence or inexcusable ignorance of what abuse victims face. The allegations implied that both Charlene and Claude Barnett engaged in acts of domestic violence in the presence of the child, when the facts clearly showed that Charlene was merely the victim. In addition, ACS claimed that she failed to cooperate with services offered by ACS when in reality none were offered. On February 4th, the family court ordered that Charlene's children be returned to her on the condition that she and the children stay in her cousin's home. Despite this ruling, there was a 14-day delay before her children were returned to her because ACS claimed that they were concerned that there were not enough beds at the cousin's home. Although adequate housing is always a valid concern for managers evaluating family circumstances, this appears to have been a fabricated reason for keeping the children away from her. She was allowed to see the children only once during this time and only under supervised visitation at an ACS foster agency. Finally, on February 18th, 21 days after the removal and 14 days after the family court had paroled her children to her, ACS returned her children. Charlie Nicholson believed that what ACS did was wrong and set out to make it right, not only for herself, but for all women in similar circumstances. "I don't care if I'm the only one standing," she says. "I'm going to go for what I believe in." This strength led to her being named lead plaintiff in Nicholson, and today she is a nationally recognized spokesperson on domestic violence and child welfare issues. Charlene was not the only woman who was being abused by New York's child welfare system. As her story unfolded, so did the stories of many other survivors, and you can read more in my article, which is coming out in the Journal of Gender Law and Policy, and also in the actual Nicholson decision, which is really fascinating to read. It's long, though. It's like 200 pages, but it's fabulous testimony. So the opinion highlighted the trauma to children of being removed from their home and placed in foster care, and Judge Weinstein determined that removal should be used only as a last resort, especially with children who have been exposed to domestic violence, because they're even more vulnerable to the emotional impact of separation from their mothers. The court held that ACS regularly alleges and indicates neglect against battered mothers, rarely holds abusers accountable, fails to offer adequate services to mothers before removing their children, regularly separates battered mothers and children unnecessarily, and fails to adequately train its employees regarding domestic violence. The court concluded that ACS practices and policies violated both the substantive and due process rights of mothers and children not to be separated by the government unless the parent is unfit to care for the child. And Judge Weinstein said, "The evidence before this court reveals widespread and unnecessary cruelty by agencies of the City of New York towards mothers abused by their consorts through forced, unnecessary separation of the mothers from their children on the excuse that this sundering is necessary to protect the children. The pitiless double abuse of these mothers is not malicious, but due to benign indifference, bureaucratic inefficiency, and outmoded institutional biases." In January 2002, the court granted a preliminary injunction. As I mentioned, the City of New York appealed. The Second Circuit held that New York City was liable, but first they certified 3 questions to New York State's highest court, the Court of Appeals, to resolve the state law questions. And Judge Kaye set a new standard for assessing whether removal is appropriate. A domestic violence victim, she said, could be defined as per se neglectful only based on failure to exercise care, not because she was a victim of domestic violence or because her children were exposed to it. An agency must conduct an in-depth assessment that includes understanding the danger to victims and to the victim and the children of leaving. And so, in other words, that separation violence is very important to understand, because Judge Kaye understood that that's the most dangerous time for victims, is when they're leaving. Courts need to pay attention to separation abuse and the risk attendant to leaving and seeking assistance. This decision had a dramatic impact on ACS policies. For several years after the decision, the removal of children declined dramatically. The number of incidences where a mother was cited for neglect because of domestic violence also sharply declined. ACS revised its program and instructions about domestic violence to reflect the decision and made experts on domestic violence available to its staff. So you may wonder, why am I here? Why is there anything to talk about? And the answer is that while Nicholson has effected significant change in the response of the courts, there continues to be difficulty in implementing culture change at ACS. ACS persists in punitive responses to DV victims. I've selected 2 cases based on interviews with attorneys at the Brooklyn Defender's Office to illustrate the difficulty of changing established patterns of behavior. I do not intend these cases to be a comprehensive review of all instances of removal, nor do I mean to imply that ACS employees have not introduced some modification of their practices since the Nicholson decisions. But this is a perfect paper topic that Tally or somebody else could do when looking at the different state court practices and the evidence. I mean, I didn't have time to get into this because I have another job that I'm doing as chief of staff at Columbia. But it's a perfect case to really focus on a state like New York and survey all the evidence. So the first case I want to talk about is called Enrage. Sharon was a 25-year-old unmarried woman living in Brooklyn. She was raised in Virginia and had attended high school and 2 years of college before coming to New York. Sharon had a child from another relationship when she met Carter in 2011. So note, 2011, pretty close to this time. Sharon and Carter were together for 1 year before her child Joy was born. Although Carter had been physically abusive in the past, once the baby was born, he was supportive, and he supported the family until he was laid off from his job. Unfortunately, unemployment is one of the key factors with domestic violence. After he was unemployed, he began to be abusive to Sharon, and she attempted to end their relationship. In retaliation, Carter called the child abuse hotline and accused her of inadequate guardianship. The hotline call triggered an ACS investigation. Over the course of the next few weeks, ACS made several home visits to Sharon. She was responsive to their request and complied with their suggestions. On January 11th, the worker began to close the case. Then, on January 22nd, Carter came home and assaulted Sharon, slamming her shoulder into a large television. He became enraged, left the room, and when he returned, he had a knife in his hand. He tried to stab her and threatened to kill her, all in the presence of the baby. Following the assault, Sharon called the police and was taken to the hospital to have her injuries treated. She obtained an order of protection. However, the preceding day, ACS had already convened a child safety conference about the family. Despite the fact that she had just been assaulted and had cooperated fully with ACS during the course of the prior 3 months, she was abruptly informed at this conference that ACS would be filing a neglect petition against her. When she reacted in despair and anger and stormed out of the conference and fear that her children were going to be taken away, ACS decided to remove Joy. The only aspect of the situation that had changed between January 15th, when ACS was closing the case, and the removal of Joy was that Sharon was assaulted by Carter and then became distraught and abruptly left the child safety conference. ACS testimony reflects that the only reason ACS decided to remove Joy was because of the statements Sharon made when she left the child safety conference, which were clearly outbursts made in frustration and out of fear that her baby would be taken away. They clearly wanted to penalize Sharon for her behavior rather than support her as a victim. Prior to being removed from Sharon, Joy had been in her mother's care for her entire life. Once she was removed, she was placed in foster care, and her contact with her mother was limited to supervised visits. At trial, the judge decided to immediately return Joy to Sharon, stating that ACS had failed to establish imminent risk of harm and that continued services could minimize the risk of harm to the child while in the care of her mother. Further, the court found that the risk of harm due to removal of the child from her mother and placement in foster care outweighed the risk of being with the mother. This case shows the effect of Nicholson in the family courts, but illustrates the challenges of changing the persistent victim-blaming culture on ACS. The second case that I'm going to discuss is called In the Matter of B Children. Adonna was a 28-year-old woman living in Brooklyn. She had 3 children, 9-year-old twins, and an infant. She was separated from the children's father and was on the verge of being evicted from her home when she became involved with James. Adonna had been experiencing difficulties ensuring that her 2 older children attended school on a regular basis, so they had gone to live with their father, and James had encouraged this. Once Adonna moved in with James, he began to isolate her, preventing her from communicating with her family and friends. After Adonna's family did not hear from her for several months, they begged ACS to locate her. An ACS caseworker was able to find her and arrange to meet with her, but James would only allow the caseworker to meet with Adonna in public and in his presence, and he made sure he was sitting right next to Adonna on a bench. He was clearly controlling her speech and movements, but the caseworker was not trained enough to perceive what was going on. Following this encounter, Adonna disappeared for 2 more months, and no one heard from her during this time. Then the neighbors in her building began to complain of unusual noises coming from James's apartment. When police responded, they found Janice and Adonna tied and bound with duct tape. James was in the room when they arrived and they arrested him. They found wounds over both of Janice's and Adonna's bodies, and they found Janice emaciated and malnourished. James had held them captive in a room for 3 months, and they had not been allowed to leave the room for any reason. Adonna stated that James physically and verbally abused her and refused to allow her to eat or leave the home. She was fearful that he would kill her and the baby because he had previously threatened to do so if she left him. Following her rescue, Adonna brought her 2 older children back to live with her and more than adequately met all the children's needs. Nevertheless, ACS brought a neglect proceeding against her and included the older children in the neglect petition and subsequently released them to the care of their father, despite the fact that the father had 11 domestic violence reports against him, and ACS was aware of this. ACS then advised the father to file for sole custody and to call the police against Adonna if she gave him any problems. Their objective was clear to separate Adonna from her children, and the father had no interest in having custody of the children. He wanted them to live with Adonna. Instead of using their abilities to support her as a survivor of abuse, ACS appeared to blame Adonna for the violence and attempted to undermine her efforts to create a better life for her family. In conclusion, the Nicholson case clearly has had an impact on the court response. Nevertheless, work needs to be done to change the culture at ACS. They need a clear recognition that children who have been exposed to DV will be further harmed by separation from their mothers. They need to shift the emphasis in safety planning from placement to support and preservation. They need to fully incorporate DV expertise into line authority to which field and supervisory staff are accountable. As evidenced by the cases described above, there are still instances where the implementation of Nicholson has fallen short of the directives. There are a variety of preventive services that ACS could offer to families experiencing domestic violence, including shelters, therapy, legal advocacy. I think you all know all the possible solutions. And ACS has improved the general availability of these programs, but they're still not in adequate supply. They need to intensify the domestic violence training offered to its employees. Caseworkers still have discretion to remove children without adequate supervision. Coordinated efforts by city agencies and the perception by victims that there are coordinated approaches improves the recovery of victims. We now have 4 family justice centers in 4 of Manhattan's bureaus. These could be training sites for ACS with ongoing and intensive training of case managers. This would do much to strengthen ACS's response to protecting victims of domestic violence and their children. That's it. Thank you all so much. Does anybody have any questions?
You mentioned that this had an impact not just in New York, but kind of around the country. Is the situation any different in other places, or does it seem to be sort of a uniform?
Well, that's a good question. I actually don't know, and I haven't researched that. It's actually a good topic that I should follow up with. But the Nicholson decision is cited in many decisions in different jurisdictions, so we know it's percolated down to the courts.
How in depth do you think an investigation should be before a child is removed from their home?
Well, I think the caseworker needs to understand whether the victim is actually persisting and the most important thing to understand, amongst other factors, is whether the victim is persisting in staying with her abuser. Obviously, this is the critical thing, but in the cases that I've examined, the victim is leaving the abuser, or the abuser isn't even present at the home anymore, or arrested, or, you know, in that sense, there is, in those cases, there's no reason to remove the children. But obviously, it has to be a layer deeper than what they're doing. It has to be they have to have a greater understanding of the domestic violence issues and balance whether the person tried to leave, whether they were afraid they were going to be killed. You know, there are a variety of issues, as I discussed. It needs a subtle and more specific understanding of what's going on in every family. So It needs to be more in-depth. You know, this is the problem. I mean, New York City is so huge. The workers who are hired to investigate these cases aren't necessarily educated yet in domestic violence. So you're constantly dealing with these pressures of, you know, if you leave the child, is the child going to be abused or killed? I totally understand the issues, but in these cases, they need to look at it more deeply.
Have there been any changes under the laws of
There have, and there is an Office of Domestic Violence, and I hope they're focusing more on these issues. I don't know any concrete changes yet, but they have an opportunity. I should actually send my article to, I know somebody from Sanctuary who works in that office, and I really should send my article to her so they can look a little bit more deeply at these issues. But I'm gonna look into that. It's a very good point also to look more deeply into what's happened. Yes, Tally.
You mentioned a particular case where, I think it was the last one you talked about, where the children were placed with their father who had 11 domestic violence complaints or convictions, or I don't know exactly what
Right.
he said, and he didn't even want custody. I'm not familiar with New York's law. Do you know about custodial presumption in New York? Like, does one exist? I'm assuming no based on this case, but is there any presumption about the custody placement of children when there is domestic violence? Like some states have presumptions that it is not in the best interest of a child to be in the custody of a domestic violence perpetrator. Some states have year limits on that. I'm just wondering what the case is in New York.
I don't know specifically, but that's a very good question, and there should be. There
Yeah,
definitely should be, and there probably is. It's not, you know, it's not a ridiculous legal situation. I'm sure they don't place children with domestic violence abusers. Why this was probably an anomaly, just because they were so focused on getting back at the mother for some reason that they placed them with the father. But that I agree with you. That was so ridiculous.
I was wondering if you had any knowledge whether guardian ad litems or if in New York they're called CASA volunteers could play any role in this situation. Because it seems like they would be able to provide a somewhat more distance view and also spend more time actually investigating the fact of the situation.
Yeah, well, that's a good point. I believe there are two things in New York. There are the CASA volunteers, which actually I'm sort of becoming involved with, but there are also guardian ad litem who are appointed by the courts in a variety of circumstances. And they could be more helpful. The problem is this removal occurs when the police are called in a DV situation. They immediately contact ACS. This is way before it rises to the case level where the court has appointed a guardian ad litem or even the CASA volunteer is involved. But you're right, they could become, I mean, what this really requires is more training of the caseworkers, A, and B, some kind of supervision by someone in authority to make sure that these kind of removals don't take place. I think the guardian ad litem and the CASA workers come at a later date, but it would be good if they could play a role once the case comes to court, for sure.
Do you think that the courts have any further role to play in compelling that kind of training and supervision, or is that going to be a political solution in your view?
You know, that is a brilliant idea. That is really a good idea, and it should, I mean, Judge Kaye's decision really did require that kind of a solution on the case level. So that's why it's sort of perplexing that these cases are still taking place. I mean, normally you have to comply with that ruling, but yeah, that's a really good idea, and that could be a good recommendation. In fact, I'm going to write that down. That's a really good. No, I have one in here. That's a super good idea, though. And I really want to write down a number of these questions, because you guys have proposed really interesting things. Normally, when I watch faculty members do these kind of presentations, they're very smooth about writing down the questions while they're talking about. I'm not so good. Oh, the CASA volunteers. That's interesting that you know about that. I mean, I know they're in every state, right? And I just went to an interview to become a CASA volunteer because it sounds like such an interesting thing. And there were people who had moved up. I think actually there was one person who had moved up from North Carolina, and he had been a CASA volunteer here, and now he wanted to do it in New York. So that's a great program.
We have a bunch of us at Duke involved in that. So we
Oh,
train us.
oh.
They come here and they train us, and then we go out to the county. We have Durham County volunteers and then surrounding county volunteers that go to school here as well. So
Mhm.
something really
Oh, fantastic. And do you have here an organization like Sanctuary for Families that provides legal services, shelter, children's holistic approach to domestic violence?
It's the Durham Crisis Response Center.
Uh-huh.
Those are in Durham, and there are different organizations in each of the counties in North Carolina that do it.
Mm-hmm.
It's not as extensive though. It's not. There aren't a lot of volunteers. It's kind of. It's not as big as things.
Mm-hmm. Well, one of the great things about Sanctuary for Families, I mean, I don't want to do an ad for them, but for those of you who are coming up to New York City, the legal, I got involved, before I was on the board, I was actually involved in some of the legal services, and it's just incredibly fulfilling to be helping somebody who, even if it's just an uncontested divorce or something very simple, it's really fulfilling to be helping them. So, yes.
So I was wondering about your perceptions of how these kind of policing efforts or prosecution efforts work alongside other policies surrounding targeting ideas of bad mothering. So I'm thinking of, in general law, we would read cases about women who were taking intravenous drugs, being prosecuted for passing drugs along to like fetuses that they were carrying, for example. And I was wondering if you had a sense of how, either philosophically or sort of in judicial writings, these concepts of bad mothering are sort of reinforcing each other or being promulgated by the same sorts of judges, or just sort of how they interact with each other.
Yeah. Well, that's a very good question. I mean, there is, and I read a very interesting student article about this that I cite in my article. There is this idea that judges, even when completely unconsciously, have this idea of the good mother in their head instead of the good enough mother. And they see mothers who are in very difficult circumstances, and they're held to an impossible standard. And you really have to articulate this so people keep it in mind when they're in these kind of situations, that you don't want to hold it to the best mother standard or even the good mother. It's a good enough mother compared to all the other environmental things that are going on. So I think that's one thing. And you asked about something else that I was going to talk about that I forgot. In addition to the good mother.
I was just thinking specifically of like one specific example of women who were intravenous drug users who were
Right.
being prosecuted for transmitting drugs to their fetuses if they were pregnant at the time. And
Right.
So, and then it's, I mean, I think this practice was deemed unconstitutional, but like it's sort of the genesis of it was this idea of like a particular form of motherhood.
Yeah.
Both ended up targeting specific kinds of women and obviously a specific idea of motherhood, even though the actual effects of this on babies was somewhat debated.
Yeah, exactly, and that's something that should be written, that really should be written about more. It's very important, and of course, what I didn't mention that is a whole other area for investigation is the disproportionate impact on women of color and poor women of this whole approach. That's a totally different issue and can be a fantastic article topic if anybody's interested in pursuing it. But yeah, for sure that's a problem, and we need education and a different approach to viewing mothers. And of course, it's so much easier to blame the victim. And that's also an unconscious approach in terms of these agencies and even the judges. It's very, very difficult to escape from that. Now, there have been areas of the country like Massachusetts, I don't know whether you saw this, Tally, but where they have tried a practice of preventing the abuse before it happens, of targeting. But there are all kinds of constitutional issues that are involved in that. But, that's a way of targeting the abuser rather than post facto blaming the victim. That's a very good point.
Do you have any sense of how likely a false positive, determination of domestic violence, by ACS is versus how often a false negative happens? Because obviously those two have very different effects. And I was wondering if, ACS is working off of some kind of assumption about how likely it is that the child is being abused or exposed to it.
Well, I do think that, and I tried to emphasize this, I mean, what I really need to do as a next step is to go into ACS and get the hard data. And actually, as I said, if I didn't have another job, I would definitely focus on this. Get all the hard data, do a statistical analysis to really find out whether these few cases are an anomaly or whether they're actually typical of their behavior now. I think ACS behavior has certainly changed after the Nicholson case, but the problem is, it's a big bureaucracy, and they fall back on their habits and the easiest thing, which is focusing on the victim rather than, and the fear, of course, of making a mistake and having a terrible child tragedy is ever present. So it's hard to know. I don't really have a feel for the depth of this approach, but and I do think there's definitely been progress after the Nicholson case, no question about that, particularly in the courts.
Is there any specific effort made to educate women in a vulnerable position about what their options and rights are in a position like this? Because it seems like
No problem.
it seems like there would kind of be this persistent fear that if they call the police when they're being abused, their children are going to be taken away. So is there an effort made to educate them about what their options are and how to?
Well, that is a brilliant point, because that is exactly what is going, that is the absurd nature of this approach of ACS, because of course that's what happens. Women are afraid to call. Now, the way to handle this is that when ACS becomes involved with the family, they need to provide services, in a variety of services, counseling, therapy, all kinds of services to the families before it rises to the level of a domestic violence abuse. It's hard to do that if ACS isn't called in until a violent incident occurs. What are you going to do? But the one area that has been a very important development is education of the police. And this has been a huge accomplishment in New York City. They've made videos, they've shown them to the police. There's been a huge impact on the behavior of the police, so they understand much more. It's interesting, the low level of the police and the higher level of the courts really understand the holdings of Nicholson, and they've really implemented them. It's just the ACS workers where it appears it hasn't been totally built into their approach.
Right. It seems like there would be a lag between any sort of change in ACS and then the public's understanding of how they operate. Once ACS changes their behavior, it's not like the public's immediately going to know that. The idea that they take children, if you call the police for violence, is still going to be out there unless they.
Right. Well, what happens, though, is that the victims call the police, and the police do not immediately call ACS.
Okay.
That's what happens. The police are much more trained to deal with it in a variety of ways, including providing shelter and counseling way before ACS is involved. But yeah, you're right. If the women perceive that, what are they going to do? Plus, there are all these issues of economic dependence on the abuser, the legal issues. There are tons of reasons for them not to call the police, not to disrupt their current situation until they're really seriously victimized.
I think it's one last question before we I was really struck by how the opinion explicitly said on like that it was bias against victims of domestic violence, because the idea of domestic violence status as discrimination against a class of people, something that I think is widely even respected within the civil rights community as much as like race and or well known, I guess, as race or sex, gender, things like that. And I know that there are cities that have passed changes to their laws and how public services are administered so that domestic violence status isn't allowed to be discriminated against. And I think DC has done that. And I don't know if New York has, or if you've seen any movement on that to say like the administration of city services is a public accommodation. It cannot be administered in a discriminatory way against victims of domestic violence.
I haven't, but I'm going to look into it right now. When I get back, that's a really, also, you guys have had brilliant questions. Yeah, sorry, I can't, I don't know the answer to that, but really excellent questions. Now I see why Duke Law School has the reputation that it does, because you guys are awesome. Thank you so much, I really appreciate it.